Welcome to this web-only segment of John Redmann Power of Attorney. We have with us Judge Bernadette D'Souza, and we're going to be talking in this segment about the use of child custody evaluators in family court. Judge D'Souza, we had a really good off-camera discussion about this topic, and I think it's mystifying even to attorneys. But people who have a debate, a disagreement about child custody, often end up having to have Your Honor, yourself, order a child custody evaluation, or these evaluators, often they're psychologists, have to do evaluations and make recommendations to the court. Why don't you give us a sort of a thumbnail sketch of when custody evaluators are used?
Okay. Generally, when a case comes before the court, I conduct a pre-trial with the attorneys and to determine what the issues are, so that there is swift resolution to the case. Sometimes there are allegations of mental health, one parent making allegations against the other parent, and sometimes you're not sure whether the parent is just doing it in order to be able to get custody of the child. And so the court, the judge particularly, does not know what is the mental health status of each parent. And so at that time talks to the attorneys about custody evaluation, or the attorneys sometimes will come into pre-trial and say, Judge, I think we need a custody evaluator. And so they determine which evaluator they want to retain. And if they can make a decision, then the court appoints an evaluator.
All right, well, let me see if I'm keeping up with you. In other words, if the parents of the child, the parents who are fighting over custody, who should have sole custody, who should have majority custody versus shared custody, if they're fighting and there's an allegation by one parent or maybe both parents that the other parent is not providing a healthy, safe home environment, maybe the other parent's being alleged to be abusive or doing something unhealthy for the child, then maybe the lawyers, one lawyer or both, will come to the court and say, I think an evaluation of the mental status of that other parent is in order to see if the child wouldn't be better off with my client, right?
Yes.
And if they can agree, if both parents can agree together on one child custody evaluator, a psychologist usually, then fine. But if they cannot agree, then it usually falls into your hands to choose on your own and appoint a child custody evaluator to do a mental health examination of one parent or both parents?
Or both parents, and sometimes observe when there's custody involved, then there is a meeting between the mother and the child, or the father and the child, so that
to observe how the parent interacts with the child.
With the child.
And well, actually both parents, but one parent with the child and then the other parent with the child?
With the child, yes.
Okay. Is the child's mental status evaluated as well?
Many a times, yes, depending on what the allegations are.
Okay. Now, you're not talking about in domestic abuse situations, although obviously that may come into play in those situations as well.
No, not in domestic abuse situation.
Okay.
What happens in domestic abuse situation, if the abuse rises to the level where there is, say for instance, the law says if there is severe bodily injury, a single incident of domestic violence, that the victim is seriously hurt, ends up in the hospital and all that, then the law says that there is a rebuttable presumption that the perpetrator is the person that perpetrates the violence, can neither be a sole nor joint custodial parent. So you really don't need a custody evaluator in those cases, because the law itself allows the judge, once the evidence comes before the judge, to then grant sole custody to the victim.
So the domestic abuser basically puts him or herself out of the running to be sole custodian for sure.
Yes,
and
or even joint custodian.
Even joint custody, because you're an abuser.
Yeah,
if you're,
and it
if
depends.
it's proven that you're an abuser.
Yes.
But back to the general category of parents seeking to have joint or sole custody when abuse is not asserted.
That's right.
If one parent says, I think the other parent is unhealthy, he or she is it's an unhealthy environment, I think he's too hard on the child, or whatever is being alleged, a custody evaluator says, well, let me observe how this parent interacts with the child.
Yeah.
Let me conduct an examination, maybe ask the person to answer some questions in an interview or in a written examination.
That's right.
And then they report back to you, correct?
Yes.
Okay.
Yes.
What are some of the things that they talk to you about? What are some of the things that they look for in an examination?
They basically go through the 12 best interest factors of what is in the best interest of the child.
12 best interest factors.
Yes, and they
some of those?
determine, and I mean, it's like who has been providing for the child with the stable environment, the religious upbringing. So that Article 134 really sets out the 12 best interest factors for the court then to weigh as to what is in the best interest of the child. And so the custody evaluator does a good job of evaluating both parents and see how they what is in the best interest of the child, but makes a recommendation to the court. And then if we go to trial, then the court determines what is truly in the best interest. I mean, they're not the ones that can say, okay, this is what we think ought to happen.
Right.
They can't take the thing that the judge has to decide. They're just providing information to court so the court can make an informed decision based on mental health, because they're the professionals.
Of course.
And so the court relies on them to come with that information to make the best decision for the children.
What if one parent learns that the custody evaluator didn't think highly of that parent? What are the options of the parent who basically got a poor evaluation?
Well, the option basically is then they try the case. And the evaluator then comes to court and can be cross-examined.
So in the cross-examination, you can
That's
say,
when I
well,
can
did you
determine.
consider the fact that I always take my child to church, and I always take my child for extracurricular activities, and did you see that I did this, that, and the other with my child? Did you factor that in? You can try and get the evaluator to reconsider her opinion maybe, or to admit that she didn't fully evaluate important information, and maybe get the evaluator to appear that she didn't do a good enough evaluation.
Yeah. But ultimately, the trier of facts has to make all the decision.
And it's not just the I didn't mean to cut you off.
Yeah.
It's not the evaluator's opinion is one of the things that you consider in arriving at your decision on custody. Are there other things that that have significance when you're determining a custody determination, such as where the parents live, where if a school is in one parent's neighborhood versus the other? What are some of the other important considerations?
I mean, it all depends on how the case comes before the judge. Attorneys, particularly there is this law which is called Bergeron v. Bergeron. It's a state Supreme Court case. There are two types of judgments. One is a consent judgment and one's a considered decree. And Bergeron basically says, for instance, if the case goes to trial and there is a judgment, Bergeron says that in order for you to now change the status in that case of the child, take from one parent to the other, you have to meet a very high burden to show that the custody in that one parent is so harmful and so deleterious that it now needs to change to the other parent. Okay. So the burden is very high.
Very high.
Very high.
All right, last thing, and this is something that I'll bet you get this a lot. After a judgment has happened, after a decision is made on custody, on child support amounts, on whatever, what is the rule about changing the terms later on? You often hear the expression material change in circumstances.
Yes.
Could you explain that?
Well, material change in circumstances is anything that under Bergeron, if it's a consent judgment, and there is a change, basically, say for instance, a father has another job, or his salary has increased and the mother has given up her job. That's a material change in circumstances which has to come before the court to then change what amount of child support that child is going to get under the Louisiana child support guidelines.
So if you calculate child support based on each parent earning a certain amount,
Yes,
and
the
then later on
expenses.
somebody's pay changes, well,
Yes.
then the calculation of child support should change. That would be a material change in
Change in
circumstances.
circumstances.
Or if a parent is later on accused of, I don't know, a crime that
Yeah.
might prove that that parent might be a bad parent,
That
and
is
the
a
other side can say, well, Judge, that's a material change in
Yeah,
circumstances.
he went to
That might-
jail. Yeah.
That might impact whether or not custody should change.
And what they call it is modification of custody,
Okay.
whether the custody
So
can be modified.
You can't just go back every month and say, hey, Judge, I want another bite at the apple. I want you to change custody. I want you to change whatever. You have to show that there's been a material change in circumstances. In other words, some sort of significant change.
Yes.
Okay. Well, Judge, it's been another fascinating discussion. We are all out of time for this special Lagniappe webinar discussion. I'm grateful to you for being with us. We are all out of time. We're going to have to wrap this up. Thank you very much for being with us on John Redmann Power of Attorney, this webcast. We look forward to seeing you on John Redmann Power of Attorney on television, and we look forward to seeing you on our website for webcasts such as this. So thank you for being with us, and we look forward to seeing you in the future. Thank you.